Good to see some fellow Virginians here. What he didn't mention is I also, a month after I stopped being Attorney General, sued the President and the NSA, which is largely what I wanted to talk to you about today. Any NSA fans here? No? Yeah, I didn't really think so, but we're on hold at the moment because we think our judge is waiting for what the DC Circuit Court of Appeals is going to say in another case, which could affect ours. But it's been very interesting the last couple of weeks to watch the technology companies sort of tripping over each other. This is really a couple of months. Apple gets more press than everybody else. So this week we saw a lot with the Apple operating system 8 rollout in their iPhone 6 or 12 or whatever they're at. But where they're giving you the power to access your phone and no one else. How novel. And I think a lot of this, all these things are related. If I remember correctly, Microsoft actually started down this road first, which you'd say, they're not the first people I'd expect in the technology world to start giving us more privacy protection. So that probably means they saw some competitive advantage to it, and so they started doing it. Well, now Apple's doing it, Google is moving this direction, Amazon, in part by moving some things offshore, so they're out of reach of law enforcement and other ways of doing this. Of course, this has all exploded since the Edward Snowden revelations last June. And there were other lawsuits against the NSA filed shortly thereafter. The ACLU argued recently in New York before the Court of Appeals, the Second Circuit Court of Appeals. We're waiting on a ruling from them. There are 2 in the DC Circuit, including our case, where you heard from my client last night, Rand Paul. My other client is FreedomWorks. It is also a class action case, so if the class gets certified, you will all be my client, and I'll be able to write the gas off coming here, so, which will be great. And then there's one other case out on the West Coast. Now, I'm going to be a little more legally geeky about this stuff maybe than you're used to hearing, because I think you all are familiar enough with this subject that that's something you might appreciate a little bit. So let me take you back 2 years to a different case. And the reason I'm taking you back is because I think it tells us why we're going to win when we get to the Supreme Court on the Fourth Amendment. And the government is going to have their ability to go get any of your personal data that you leave, say, with your phone company, fill in the blank, iCloud, all around the world here, that right now they can go just take. You have no Fourth Amendment protection for that under a case called Smith v. Maryland from 1979. So let me go back 2 years now. 2 years ago, there was a case called Jones. And in the Jones case, some police in DC put a tracker, a GPS tracker, on Jones's wife's car, but for all purposes, Jones is all that really matters. But they didn't have a warrant to do it. And they tracked him around for 28 days, saw everywhere he went, used that information to help convict him of drug dealing. At the Supreme Court, there was a 9-0 decision that violated the Fourth Amendment. 9-0. Now, it wasn't as 9-0-y as 9-0 would sound. It was seriously split as to why 2 different groups in particular, 3 if you take Sotomayor by herself, decided the way they did. The majority of 5, the opinion written by Justice Scalia, said putting that thing on the car was a physical trespass without a warrant. And that crosses the Fourth Amendment line when you're tracking this person with the GPS device. Now, one thing to realize, when you drive your car off your property, because anybody can see it, there's nothing private or secret about that or protected by the Fourth Amendment. It's why police officers can grab your license plate on the road and record it. There is no Fourth Amendment problem with them doing that because you're showing the whole world your license plate as soon as you leave your property. So the focus of our lawsuit is the Fourth Amendment, and that's what I'm going to drill down on here. The majority said the Fourth Amendment was violated in this GPS tracking case when the tracker was put physically on the car. Okay? Then there were two other opinions. Sotomayor was concurring by herself. She also joined the majority opinion. You can do that. You get to vote more than once if you're on the Supreme Court sometimes. And then in a concurring in the result, which means they disagreed with Scalia's reasoning, written by Alito, which is very interesting. Now, Alito was joined by the three liberals other than Sotomayor in his opinion, and what he said was, I don't care about the trespass. What matters is they tracked this guy every move, everywhere he went, for 28 days electronically. And the analogy Justice Alito used back to the founding period, because the Fourth Amendment became part of the Constitution in December of 1791, he said this would be like a constable hiding in the back of a carriage for a month, following you, actually going with you everywhere you went. And that's not going to happen. It never happened. It would never happen. As a practical matter, it was never going to happen. Justice Sotomayor talked about some of the practical impediments that protect our Fourth Amendment rights. Budget. The police can only hire so many people. Well, if you can just track everybody electronically, you have avoided that practical impediment. And that has implications for Fourth Amendment analysis. Justice Sotomayor explicitly said, I think it's time to revisit how we look at Fourth Amendment rights in the digital age. Alito said, all we need is this electronic tracking to find a violation of the Fourth Amendment. And with other things Justice Sotomayor said, you add the Alito opinion with 4 and Justice Sotomayor, those 5 justices, at least those 5, not to say there won't be more than 5, when the NSA case gets to the Supreme Court, I believe, are going to say that in the electronic age and the digital age, we have not been applying the Fourth Amendment right. Not that we're rewriting it, that we've been wrong since 1979. It is very rare when I can point to a case in the litigation pipeline and name the 5 justices that I think are going to rule our way. Litigation is very uncertain business. And this is a very unusual situation to be in. So let me tell you about another case decided in June. And for those of you who don't follow the Supreme Court too much, their term runs from the beginning of October to the end of June. And the toughest or most newsworthy, for lack of a better description, cases tend to be decided in June. Well, this June, there was a case, Riley v. California. And in that case, the Supreme Court altered a 41-year-old rule related to arrest, custodial arrest. When the police arrest you, legitimately arrest you, and detain you, legitimately detain you, they can search you entirely. And they can take your purse and they can go through your purse. And until June, they could go through your cell phone. This is all based on a 1973 case. And the reason at that time was, well, they got to be able to make themselves safe, 1, and 2, they've got to be able to catalog the property. So if there's a dispute, that it's been documented what was there and what wasn't. Well, the Supreme Court in June said, you can no longer search that cell phone. You can hold the cell phone, you can catalog that you have the cell phone, you being the police in this situation. But if you want to search that cell phone, Mr. Police Officer, you have to go get a separate warrant where you have to demonstrate probable cause to a judge, which is what the Fourth Amendment requires. When I look at that Riley case, and some of the language by Justice Roberts, Chief Justice Roberts, who was not in the, sort of my Jones 5, if you will. He wrote in there how different cell phones are, which we've been arguing, how they completely change the analysis. I mean, that cell phone you've got, first of all, is with you all the time. It can be used to track you, obviously. We all know that. But it can also contain more information than a room full of file cabinets, and you're just carrying it around with you. And for a lot of people, that has become your computer. And the Supreme Court is gradually catching up, and they said, this is just not like cataloging property and making sure this person we've arrested doesn't have a weapon. This is different. This implicates the Fourth Amendment in a way that other materials haven't in the past. Now, interestingly, through the last few decades, there have been justices who've said, the government's ability to gather all this data is a really big deal. It's going to change our analysis one of these days. By implication, not today. Well, folks, I am confident that day is coming. And that day, I believe, will be within the next 21 months. I don't believe it'll be this Supreme Court term, but I believe in the next one of these NSA cases is going to go to the Supreme Court, and I believe they are going to say the government has no Fourth Amendment authority to be grabbing all of our telephone data from Verizon and AT&T and Cricket and whatever else, which they've been doing for years and years and years. And don't just look at the Patriot Act. Right now they say they do it under Section 215 of the Patriot Act. Well, the Bush administration was doing it before there was a Patriot Act. So when they come to us and say, well, we're not doing it under the Patriot Act anymore, and they're going to try this, I'm sure, to try to get the judge to just lay off them, our retort will be, Judge, they've been doing this since before the Patriot Act. They're not relying on that. We need a ruling that this violates the Fourth Amendment in all instances where there hasn't been particularized suspicion about the phone owner or the phone number that they go after. Note that's one, not 300 million. If this class is certified, there aren't going to be many people that won't be my clients. So, because there are that many cell phones out there. And a lot of people have more than one. Work, phone, work, home, other things. So that's the very big picture. And I believe that by June of 2016, interesting timing, the NSA will have this ruling against it and will be forced to stop the generalized collection of our metadata that they get now through the FISA court order that we're arguing, of course, violates the Fourth Amendment. So there are a lot of things about government and the course of it that I'm pessimistic about. You've probably heard about some of them from other speakers. We're going to win this. Whether it's our case or whether it's the ACLU in New York, and it is amusing. The last couple of weekends I've been doing privacy presentations with the ACLU in Virginia. It's very uncomfortable, but when you're right, you're right. And so I don't have any, I joke, but I don't have any problem teaming up in that respect. And in fact, the lawyers for the other case that I've talked to the most are the ACLU lawyers in New York. It's a very interesting cross-partisan issue. And if I could just touch on politics 1 second and then go to the next legal issue. Last year, of course, I lost the governor's race by 2.5%. Interestingly enough, for a Republican, I won voters under 25 by 6%. And still lost. It is issues like this Because in Virginia, I literally don't know of anyone, while anybody in this room is alive, who's been as aggressively pro-liberty as I was as Attorney General. And that resonates particularly strongly with younger voters. It is consistent with other things I was doing, and so it wasn't all by itself. But that approach, we had a drone policy. I mean, how many candidates have a drone policy? And you all can probably guess what that read like. And the word warrant showed up, amazingly enough. And I did have the opportunity to issue an opinion on license plate readers and the keeping of that data. Now, this is under Virginia law, not the Fourth Amendment. Because remember, I told you, with your license plate, when you drive off your property, you're showing the world. So there's no Fourth Amendment protection. But now let me tell you about one other legal issue that I've really learned about in this NSA case that I don't have an answer to and that I don't see anybody trying to address. The reason the NSA wants all this metadata is because looking at the data of 1 million or 100 million phones, et cetera, pick the number, tells you an enormous amount more about each individual's use of their phone than just looking at that individual's use of their phone. This is big data. When you do various things at various times in various ways, well, that's neat, we watch you, we try to figure out a pattern. But if I can look at 1 million other people and find all the others who fit that behavior pattern, I'm starting to learn things about you with a higher and higher degree of confidence. I watched a little video about a debate between a New York professor and General Hayden, Michael Hayden, who used to head the NSA. And the professor said something along the lines of, what a big deal metadata is and how much it tells you. And General Hayden, rather than arguing against that, which the lawyers, by the way, in our case are arguing, no, it's no big deal. You know, we just collect this stuff for a hobby. You know, you know, they play it down in court, much like in the healthcare case. They walked right in and brazenly said, oh yeah, it's a tax. Well, no, wait a minute. You've been telling us it's not a tax for 2 years. Oh, you mean that tax? Well, in court, they're saying it's not a big deal. You know, it's not, doesn't rise to the level of constitutional problem, blah, 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 blah. Well, General Hayden's response to that professor was, oh yeah, we kill people based on metadata. Whoa. I appreciate his honesty. And to give you an idea of why metadata can actually be more valuable than listening to your phone call, think about everybody in this room here. Just think about the people in your row. To say the same sentence, I am going to go to Alexandria and try and find a Republican. You know, if everybody in your row said that same sentence, they'd say it a little differently. The drawl would be different, the speed would be different, the cadence, it'd all be different. Well, when you dial a phone number, and I dial a phone number, it's the exact same data. So I can pile that in a database and process billions of those records in no time. I have a really hard time, technically, comparing one person's conversation, the substance, which is what we usually focus on in constitutional protection, versus another person saying the same thing. I can't get my computers to track that efficiently. I just can't. Guess it's one of the beauties of the differences from one person to another. But that metadata is absolutely standard across all of us. How powerful is it? A couple of Stanford Law computer science students in the end of 2013 and into 2014 ran a sort of informal test. They got about 550 volunteers, all of them with Android phones, who agreed to essentially be tracked and have their metadata tracked as if it was being dumped into a database. And then after 3 months, they analyze it. Now, mind you, this is only about 550 people, not 100 million. Well, in only 3 months, with just that number of people, they could figure out who owned guns, who had what medical conditions. They could figure out the religion of about 1/6 of them. Of course, political affiliation for a lot of them was easy to figure out, all just based on metadata. Who got an abortion? Some of the material on that was kind of chilling. And as I said, specific illnesses, not just that you were sick, but you call a particular number that's a hotline to deal with one disease. Well, if I know you're calling that number, that tells me something. So this is a real problem. So back to the big data for one person. Our Constitution and your rights are written in such a way that you can enforce protections when the government is aiming at you. But if they're going to get all of your metadata, they can figure out a lot more about me with your data. Well, how do I even know to go to court to say, no, don't let them have all that? Because that gives them insights on me that violate my privacy rights. That's a really tough legal challenge. And like I said at the beginning, I don't have an answer to that. I don't have an answer to that. So that's your legal tongue twister, I guess, for the day. Can all start chewing on that one. But it isn't necessary for us to address that to get through the NSA case. But in looking at the metadata and the use of it and what it can do, I have been thoroughly educated about the existence of that problem. And it's one that I don't see anybody facing up to, that I don't see anybody analyzing aggressively, but we're going to have to deal with that as big data gets bigger and bigger and bigger. So that's the challenge out there. But when it comes to the NSA case and others like it, whichever ones get there first, I think we're going to keep making progress in court, and ultimately we're going to get a big win. Again, you heard it here first, June of 2016, and I think it's going to be very meaningful reestablishment of individual rights in this country. Oh, you mean that Bill of Rights, you know? And the Constitution is there to govern government. It's the biggest lawbreaker in the world, and it's to protect us against government. It isn't to protect us against Verizon. It isn't there to protect us against our neighbor. It's there to protect us against government, especially the Bill of Rights. And we're doing that. We're doing that, and I think we're having success, and I think we're going to have ultimate success at the Supreme Court. So I'm happy to take questions on any of this, and I appreciate you all having me. So, time? Okay. So does that mean you don't want me to take questions? Okay.
You can take a question.
Okay.
Question.
Yeah, I'm not in charge. I just answer them.
I'm sorry, but would you mind doing in kindergarten-like format, summarizing what you're saying this, I'm having
on
trouble.
The NSA,
right.
You mean?
What do you say, and what are the implications of them having them? What can they do with the metadata?
Oh, the metadata. Okay. Well, first of all, they can figure out a lot of things about you. They can figure out health issues, family issues, just personal everything. I mean, pick one part of your life and think of what you do with your phone that's related to it. I call my sister to talk to her about it. You know, it could be anything. There are innumerable number of things. Health is an easy one to talk about. What products you own or buy is another easy one to talk about. They can figure a lot of things about you with your metadata. They can figure out where you go. It depends what they want to do with it. The follow-on was, and do what with it? If government believes that you are bad in whatever way, they can build a case without going to a judge to get this information without having to demonstrate probable cause that you are or may be a bad person in the eyes of the law, they can build that case without the judicial oversight. And remember, the founders wrote the Fourth Amendment because the king and his agents, they wandered right into your warehouse and checked out what you had to see if you were obeying the law with what were called just writs of assistance, which was just a permission slip from the king. They just needed to not like you. Let's go check out John Hancock's warehouse today. And the big case on that was in 1761. And interestingly, John Adams says that's when, what did he call it? The baby called revolution was born. And it was about this inability for any zone of privacy against the government. And so that's the motivation for the Fourth Amendment. And it is the right to be left alone. I mean, the Fourth Amendment is where that is written into the Constitution. It is the right to be left alone. And in Virginia, the Constitution was barely ratified. 88 to 80 was the key vote. We all assume it now. Patrick Henry voted against it. George Mason voted against it. Then Captain, later President Monroe voted against it because it didn't protect these kinds of individual rights. That's how important they were to those founders. And, I'm very glad to be up and able to fight for them today. These battles don't end. It wasn't won in 1776 and 1781, and okay, we're done. We are still contending with the greatest threat to liberty outside of an invasion that takes us over that the founders thought we would contend with, and that is our own centralized federal government. That's it. So, thank you all very much. It's been a pleasure to be with you.